Hello, my name is David Nash. I'm the Director of Legal Education for the Foundation for Educational Administration, and I'm the coordinator for the Legal One program. The presentation that you're going to be hearing is about a very important decision involving the Ramapo-Indian Hills School District. The decision addresses how school districts are entitled to deal with students who are athletes or involved in extracurricular activities who may engage in inappropriate conduct away from school grounds. As a result of this presentation, it's important for you to understand the parameters for addressing conduct away from school grounds in light of this decision in GDM versus Ramapo-Indian Hills School District. As a result of the presentation, we want you to be comfortable in identifying key issues to consider when it comes to revising district policies regarding conduct away from school grounds. We also want you to understand the decision in light of ongoing requirements related to harassment, intimidation, and bullying, and dating violence. So to review the case of Ramapo-Indian Hills, on January 22nd, the New Jersey Supreme Court decided not to hear the Ramapo-Indian Hills case, in effect leaving intact the prior decision of the Commissioner of Education and the Appellate Division. This case does have far-reaching implications, but we also want to make sure that you don't misunderstand the full meaning of the case. The case will require, for many school districts, changes in typical 24/7 policies that are in place for their high school athletes and in some districts for students who are involved in other forms of extracurricular activities. But as we'll review, it does not change any requirements related to reporting on harassment, intimidation, and bullying. It does not change reporting requirements related to dating violence or requirements that are involved when a student is suspected of being under the influence of drugs or alcohol. As background, New Jersey has for many years had a standard for when school districts have the right to address conduct away from school grounds. There was a major case that came down in 1970, RR versus Shore Regional School District. And that case really laid out the parameters for dealing with conduct away from school grounds. In that particular case, we had a student who was disciplined for threatening another student with a knife. The incident occurred off school grounds. It was not at a school event. In this case, the district determined that the student who was victimized was fearful and that this caused substantial disruption to his education. The district decided that it needed to impose a suspension on the student who had threatened the other student. This case established a very important precedent, the right for school districts to discipline students for conduct away from school grounds. And the decision of the school district to impose that discipline was ultimately upheld. The principles that were laid out in the RR versus Shore regional case have now been embodied in the New Jersey Administrative Code. Specifically in 6A16, 7.6 of the Administrative Code, we have language that lays out the parameters for how school districts can address conduct away from school grounds. So the school district's actions must be consistent with the district code of student conduct. Very important that school district personnel understand and consistently implement their code of student conduct. We may also only exercise the authority to deal with conduct away from school grounds when it is reasonably necessary for the student's physical or emotional safety, security, or well-being, or for the safety, security, and well-being of others. We may also only exercise this authority to deal with conduct away from school grounds when the conduct that's involved materially and substantially interferes with school discipline. There's also a provision built into administrative code that deals with students involved in extracurricular activities. A district board of education may deny participation in extracurricular activities as a disciplinary sanction where such measures are designed to maintain the order and integrity of the school environment. So we do have the authority in some cases to deal with denying participation in extracurricular activities. Important in the Ramapo-Indian Hills case, however, was that we have to show a nexus between the behavior that occurs off school grounds and the proposed discipline that is going to be imposed in school. So let's review the key facts involved in the Ramapo-Indian Hills case. In this case, the board had a policy that addressed conduct for students involved in extracurricular activities. This policy stressed that participation in extracurricular activities is a privilege. It's not a right. The policy was intended to support students in refraining from drug and alcohol use. The policy laid out that students must not engage in activities that constitute criminal offenses or juvenile delinquency, and that students must refrain from the use, possession, or distribution of alcohol or drugs both on and off school grounds. The policy included specific consequences for students who violated the provisions. For example, for a first offense, there was a potential removal for 7 school days from the extracurricular activity or sports. For a second offense, there was a removal for 90 school days. And for the third offense, there was a removal for 180 school days. Very, very common language in this policy, very similar to the policies in place in many other school districts in the state. The commissioner, in reviewing this particular case, agreed that participation in extracurricular activities is a privilege. One of the things that the school district had argued was that it had the right to suspend or remove a student from extracurricular activities because, in fact, this was not something a student was entitled to participate in, and it was a privilege. But even though the commissioner agreed that participation in extracurriculars is a privilege, the commissioner rejected the district's claim that the denial of that participation was not a form of discipline. So the commissioner said this is a form of discipline, and as a form of discipline, there are simply too many examples where the type of policy involved here would exceed the authority of the Board of Education. So the commissioner said that school districts need to show a specific nexus, a specific connection between the conduct away from school grounds and student safety and well-being, and they need to show that the action is necessary to prevent material and substantial disruption of the school environment. So let's think about the implications of this decision for your board policies. As a result of this decision, it's clear that school districts cannot suspend or remove a student from sports or other extracurricular activities solely because the student was involved in the use of alcohol or drugs off school grounds, or solely because the student may have engaged in criminal activity or juvenile delinquency. The school district has an additional burden. They need to show that there is a specific nexus, a specific connection between the conduct that occurs off school grounds and the school environment. As we mentioned earlier, any school district action to deal with conduct away from school grounds must comply with the provisions of New Jersey Administrative Code. And those provisions, again, are laid out in 6A 16 7.6 of the Administrative Code. Critical at this point in time for school districts to recognize that they may need to revise their existing 24/7 policies. School districts face great risk. If they fail to revise their policies, it could lead to significant liability. Now that all school districts are on notice that the traditional 24/7 policies are not acceptable under the decision of the Commissioner of Education. So let's think about when school districts do have the right to address conduct away from school grounds in light of the Ramapo-Indian Hills decision. We'll talk about if, when, and how to apply the potential sanctions for conduct away from school grounds when it comes to bullying and cyberbullying, when it comes to students who are suspected of being under the influence, when it comes to potential teen dating violence, when it comes to the assault of other students or threats against students or staff, or criminal activity. In addition, we'll review violations of 24/7 policies and contracts for student athletes. In order to put all of this into context, we should take a moment to review the definition of harassment, intimidation, and bullying. There are certain key elements that school districts must identify if they're going to deal with conduct away from school grounds that we believe rises to the level of harassment, intimidation, or bullying. First, the conduct must involve an actual or perceived characteristic. If we're unable to identify the motivating factor, the characteristic that drove one student to target another student, we cannot label the behavior in question as harassment, intimidation, or bullying. It may be some other violation of the Code of Student Conduct. You may still be able to impose discipline, but you must identify an actual or perceived characteristic in order for us to label the behavior as HIB. The behavior also must involve substantial disruption or interference for at least one student. So, if we have a case where there is a disagreement between two students, perhaps some inappropriate words are used back and forth between the two students, and the students are playing together and laughing and they're best friends 5 minutes after the incident occurred, chances are there was not substantial disruption or interference with the school environment for either of the students. And that is a major factor. Without that substantial disruption or interference, we cannot label behavior as bullying. In order for us to meet the bullying definition, we also must have one of the following three elements. We need to show actual harm to the student or the student's property, or that the student was placed in reasonable fear of harm to themselves or their property. Or we must show that the behavior in question was demeaning to the student or some group that the student is associated with, or that the behavior creates a hostile educational environment. So we must have one of these three elements in order for us to label behavior as harassment, intimidation, or bullying. As noted earlier, we also have to make sure that we're addressing the specific standards laid out in New Jersey Administrative Code for conduct away from school grounds. In addition to harassment, intimidation, and bullying, there are obviously other types of student misconduct that may occur on or off school grounds. One issue that many school districts have not spent a great deal of time looking into and addressing, and it is critical that we all understand, is the issue of teen dating violence. So I would urge school district officials to take the time to review the model policy developed by the New Jersey Department of Education dealing with teen dating violence. New Jersey revised its law and put in specific requirements for reporting, investigating, addressing, and having a curriculum in place to help prevent teen dating violence. And that legislation was signed in May of 2011 and went into effect in September of 2011. Under this new law, there is a very broad definition of dating violence. It is not limited to physical abuse of one dating partner by another. It incorporates emotional abuse and the intent to control a dating partner. Unfortunately, there are a significant number of teen dating relationships where we may have emotional abuse and the intent to control a dating partner. In order for something to rise to the level of dating violence, it must also involve a pattern of abuse. So it can't be a one-time incident, but again, where we have single incidents, it is not uncommon for us to also find a pattern of abuse. The behavior also must involve conduct that occurs on school grounds. So with teen dating violence, it's possible that some of the behavior is occurring on school grounds and some may be occurring off school grounds. In order for school districts to address the dating violence issue under New Jersey law, we must identify some behaviors that have occurred on school grounds. In the model policy developed by the New Jersey Department of Education, there are specific protocols for how we report and investigate dating violence issues. It's important to know that there are some key differences between the process used for bullying and the process used for dating violence. So we urge you to take the time to review your district policy and the department's model policy regarding these protocols. There is some overlap. There are some issues that will meet both the dating violence definition and the definition of harassment, intimidation, and bullying. Certainly, within the context of athletics, you may have one student athlete talking with classmates or talking with their teammates and bragging about a dating relationship that they're involved in. There might be locker room talk of inappropriate behavior going on in that relationship. And even if the original acts of dating violence are occurring off school grounds, once the student brings that into school and starts talking with their teammates about it in the school environment, at school events, it now becomes something that falls under the dating violence requirements that school districts must address. Another example of conduct that may occur on or off school grounds that certainly could involve student athletes and kids involved in other extracurricular activities is the issue of drugs and alcohol. New Jersey has a specific statutory requirement on how we address issues of students suspected of being under the influence of drugs or alcohol. In the New Jersey statutes 18A 4812, we now have very specific, clear language requiring school districts to take immediate action if a student is suspected of being under the influence. It's important to note that there is no discretion for school officials on this issue. If you have a teacher, a coach, a secretary, another staff member report to the school principal or the assistant principal that a student may be under the influence, that student must be sent out for an immediate medical examination. There was a case called Graceffo, decided a number of years ago, that laid out a bright line rule where school officials cannot in any way use discretion to decide to not send a student out for a medical examination. Viewers in listening to this particular presentation are urged to review your board policies and follow those procedures as far as how and when you deal with suspected drug or alcohol issues. But keep in mind that in no case can you decide to overrule another staff member who indicates to you a student may be under the influence. One time that this issue might come up involving student athletes, perhaps we have a student who, frankly, was at a wild party the night before. The student shows up the next day, appears to still be under the influence. The coach might see that student and be concerned that the student is still under the influence. That student, at that point in time, needs to be sent out for a medical examination if they appear to still be under the influence of drugs or alcohol. There are slightly different requirements, but specific requirements for dealing with students who are suspected of steroid use. In those cases, the student must be sent out for a medical examination as soon as possible. The statute does not specifically require that it be an immediate medical examination that day. There are other issues that involve mandatory reporting to law enforcement. So if a student is suspected of being abused or neglected, school officials are required to report that to DIFAS, and then the school district is required to have a procedure so that law enforcement is contacted every time DIFAS is contacted to deal with suspected abuse. We have offenses involving controlled and dangerous substances. If a student brings those substances to school, there is a mandate for law enforcement to be contacted. There are some specific exceptions as far as contacting law enforcement if a student specifically confides with a SAC regarding their individual drug use. But in any case where a student is bringing controlled dangerous substances into the school, law enforcement must be contacted. There are potential issues involving custody disputes, even extreme cases where potentially one parent may not have the authority to take a child, and we might have potential kidnapping issues, and obviously in those cases law enforcement must be contacted. Sexual offenses that occur on school grounds or at school events, obviously law enforcement must be involved. We need to be very careful with offenses involving the use of technology. For example, if a student is inappropriately using a cell phone during school, perhaps in the middle of class, it's appropriate for the teacher to take that cell phone from the student and turn it over to the principal and then contact the parents. Simply because the student is using a cell phone, it is not appropriate to search that cell phone. Viewers are urged to review your board policies and are urged to have school principals and assistant principals take the lead when it comes to making decisions on any sort of student search. We must also involve law enforcement when we have potential weapons issues occurring in the school. In addition, law enforcement must be involved when we have planned or threatened violence. Issues involving any sort of threat of violence to a staff member or a student, in those cases where there's the potential for significant or serious bodily injury, we must involve law enforcement. There are other cases where we have permissive reporting. Students who are suspected to be under the influence and are sent out for a medical examination may be reported to law enforcement. But this depends on board policy. Many school districts have a policy where those students are not reported to law enforcement because at that point in time we don't know whether the test result is going to come back positive or not. So it's important for you to review and know your board policies on that issue. Students who bring alcohol onto school premises or to school events, again, may be reported to law enforcement, but it's not a mandate. You must know your board policy on that specific issue. So, in summary, let's just take a moment to review, again, the Ramapo-Indian Hills decision. This decision requires a careful review of what we call 24/7 policies that are in place in many districts. Even in cases where students voluntarily sign contracts saying that they agree not to get in trouble with drugs or alcohol or law enforcement outside of school, and in this contract it says that the student understands they might be suspended or removed from the extracurricular activity or sports team. Even in those cases, it's no longer appropriate to enforce an automatic removal from extracurricular activities or sports just because a student was in trouble for conduct away from school grounds. We must make sure that before we impose any sort of suspension or removal of a student from extracurricular activities that we are meeting the specific standards laid out in New Jersey Administrative Code. This will require for most school districts a change in your board policy dealing with 24/7 issues. So we urge you to take the time to review your board policies and make the appropriate revisions in light of Ramapo-Indian Hills. It's important to note, though, that there's nothing in this decision that impacts on our reporting requirements when it comes to harassment, intimidation, or bullying. Clearly, it meets New Jersey standard when we have one student who engages in bullying of another student away from school. And in those cases, we still must deal with the conduct. Those who are listening to this presentation may also be interested in the series of ongoing trainings that we are doing regarding legal liability issues and athletics. The Legal One program has partnered with NJSIAA to offer a series of trainings on various aspects of school law and athletics. So on March 13, 2013, we are offering a program on student athletes' health issues in the law. And that program has specific medical experts coming in and discussing various aspects of student health, including concussion law, steroids, other issues where students may be at risk and their health may be at risk. We're going to also be doing a presentation on April 23rd at NJSIAA and on April 25th at EIRC that deals with athletics, school finance, and purchasing issues. And there are many examples where school districts have run into problems for failing to do proper accounting and proper financial protocols when it comes to athletics. And as part of that program, we're also going to be addressing legal issues related to Title IX and the specific requirements that school districts have. We have a series of other Legal One programs that we offer on a wide array of aspects of school law, so I would encourage you to review the Legal One website for additional information and additional resources. So with that, we thank you for taking the time to listen to this presentation. We urge you to review your board policies, and if necessary, we urge you to put in place the appropriate revisions so that we are not in violation of the Ramapo-Indian Hills decision. Thank you very much.